Mark Levine, Excel Bradshaw Management Group. From time to time, I like to hit up the New York City real estate related websites, and today is no different. On Habitat Magazine, which is habitatmag.com, they have a board talk forum section, and a question came in not too long ago that I thought was interesting, and I answered it, and I think that my answer was cut and dry, so I figured I would come over here and let you know all about it. So the question was basically summed up as this. A shareholder moved a sublet into their unit without the application, without a board interview, and without approval. So does the board have to go towards evicting the sublet by themselves, or do they go after the shareholder instead? So my answer was that the board has the relationship with the shareholder and not with the sublet. They don't recognize any sublets. They don't have any dealings with the sublet. They deal primarily only with the shareholder. So they would have to go after the shareholder for the breach of the proprietary lease. Now, without seeing it, because it's a generality at this point, the proprietary lease probably states that they need that all lessees, all shareholders, have to have prior written approval to place a sublet into their unit. And obviously, if that's the case, which it is in most cases, that was breached. So upon hearing this as a property manager, what I would do is I would send a certified written letter directly to that shareholder, noting that they are in breach of the proprietary lease and state why. And if there is a house rule that calls for a penalty or a fine based on this particular breach, I would also say your unit will be fined this amount of money. And I will give them until a certain date that's approved by the board, and potentially if you want to bring the legal counsel for the cooperative into this discussion as well, I always recommend that, that person has to be removed by such and such date, or else the board will move forward with legal action, and you will be responsible for all costs and penalties associated with that legal action, as it is a direct result of their breach of the proprietary lease. So the board, to sum up, cannot go after the sublet. You can't throw them out. You can't change the locks. You have to go after the shareholder and use the corporate documents as the way for you to get that sublet out, and to also provide relief for the breach of the proprietary lease. So I hope that was helpful. It was a quick little tip, and I thought that would come in handy for some boards out there, particularly in this area. If you want to like us on Facebook, you can at facebook.com/XLBradshaw. If you want to follow us on Twitter, we are at XLBradshaw. My email, always open, and I always respond. It's mblevine@ebmg.com. And I hope that tip was great, was for me. Till next time.